Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. If you're not sure what your workplace rights are, this is the show for you. Welcome to Ask a Lawyer. I'm your host, Dana Levinson. Every week, we shatter myths and clear up the confusion about your employment rights in Canada and how to get the advice and compensation you need. Joining us is employment lawyer Lior Sampiru, partner at employmentlawyer.ca. Before we get to today's questions and phone calls, Lior, tell us why you feel it's so important that everyone knows their employment rights.
Well, Dana, I'm sure most people spend most of their time at work. We spend more time working than we do anything else, more time than we spend, doing our hobbies or spending time with our families. So work is an important part of our lives, and we need to understand what our rights are. We spend so much time doing that, and it's naive to think that things are always going to be great, that everything is always going to be just perfect. There are going to be times when you're not sure if something is going wrong, right or wrong, and your employer may do something or say something that raises an eyebrow and you don't know what to do. Well, this is exactly what the show is about, to make sure that we fill in those gaps in knowledge about your rights when it comes to your job, when it comes to employment law, what to do if you're mistreated, if you lost your job, if your job changes, if your hours change, you name it, we address this on the show. This is something that everyone should know, everyone should be aware of. And of course, we'll give my contact information if we ever want to reach out to me and have that private chat. And, now that we know what we're going to do, let's do it. Let me tell you.
Yes, tell us about a case this week.
Yeah, situation that came across my desk. And, I really felt bad for this person. This particular gentleman that I spoke with had to take off some time because of cancer. He was diagnosed with cancer. Fortunately, it was the type of cancer that can be treated. He underwent some chemotherapy, but had to be off work, provided his employers a doctor's note to tell him that he's going to be off work. No problem, went off. And fast forward about 6 months later, thankfully and terrific, he was feeling better and was cleared to come back to work. So he was very excited, contacts his employer and says, guess what, employer, I'm better, I'm ready to come back to work, I can start next week. His employer writes him back, and we were doing this over email, saying, well, wait a second, we haven't heard from you for 6 months. We had assumed that you had long since quit. We don't have a job for you. You never contacted us while you're off. So from our perspective, you quit months ago. Obviously upset, distraught, especially having gone through what he had with his cancer, he calls me. And he wants to know, wait a second, did I do something wrong here as the employee? All I was doing is trying to get better, undergoing some very serious medical procedures. What are my rights? So, I obviously felt very bad for this person, but from a legal standpoint, this is not a complicated situation. He does not have to keep knocking on his employer's door and saying, hey, here I am, here I am. He can be off as long as is needed. His employer knew that he was off. His employer got that doctor's note and knew that this person is off for a serious medical issue. If that employer had questions beyond that, how long are you going to be off? Are you still planning on coming back to work? They could have asked the question and gotten that information that way. But to say that the employee didn't contact them and that's how they quit, that's ridiculous. That's nonsense. So we're talking a human rights violation here. We're talking wrongful dismissal. Not exactly what this employer should have been doing. I'm going to help this person make sure that he gets every dollar that he's legally owed. If you ever find yourself in a situation, if anyone you know, when you're off sick, your employer's not allowing you to come back, they're trying to blame you for doing something wrong, you really have to give me a call.
Okay. If you want to get in touch with Lior and his team, you can call 1-888-861-4555. Email ask@employmentlawyer.ca or visit their website, employmentlawyer.ca. Let's kick things off by taking our first call. Lior, these calls come from your radio show across Ontario and Canada, where you take live questions from listeners about their employment law issues. Take a listen.
This week, they actually put out packages for voluntary retirement, which I received. But when I look at it, it's not that great. I'll be there 19 years in July. I'm an analyst. I am 58.
She's 58 years old.
Obviously been there a long time.
Yep.
So let's talk about this concept of voluntary retirement. The idea behind that is that an employer is given a choice. You can continue working, no problem, but if you want to leave, we're willing to do something for you. We're going to offer you this package. Now, because the employee has the option to continue working, they're not being terminated, they have the option to continue working, the law kind of stays out of it. So the law imposes severance obligations when an employer decides to let you go. But if you're not being let go, you're just given the option to leave with compensation. There's no laws that apply here, and you can decide to accept what you're happy with or reject something you're not happy with. Yeah. But as a frame of reference, it's always a good idea to find out how much severance would I be owed in a termination situation, so that you can compare what you've been offered with what you'd be owed in a termination situation. So let's do that right now. Let's use our severance calculator, which you can find, and anyone can find, at pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca, completely free and anonymous. And let's see what that gives us. So we know that this person is an analyst, been there for 19 years, 58 years of age. In a termination situation, you can see on the screen that she'd be owed anywhere between 18 to 24 months of severance. 18 to 24 months. So if she's been offered something in that range, certainly that would be a good offer. If it's significantly less than that, then it's certainly something she may not want to consider. And it's that easy, Dana, to find out how much you or anyone else is owed. Just go to pocketemploymentlawyer.ca.
Okay, we're going to talk a lot about severance in a moment. First, let's take a short break. When we come back, employment lawyer Lior Samfiru from employmentlawyer.ca will explain why people accept bad severance offers. Ask a Lawyer returns in just a moment. Stay with us.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask a Lawyer. Employment lawyer Lior Samfiru from employmentlawyer.ca is answering questions about your workplace rights. If you want to get in touch with Lior and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. We have more calls and emails coming up, Lior. Before jumping to all that, let's talk about why people accept bad severance packages. So fact number one, the employer alleges that the employee was fired for cause.
So let me paint this scenario for you. You're an employee, and you know what? You did something wrong. You made a mistake. You clearly know you did something wrong. The employer says, wait a second, you made this mistake. We have a right to let you go with no severance because of that. But we're going to be nice. We're going to offer you a little bit of severance, and if you don't accept it, we're just going to pay you nothing. Well, and many people in that scenario will think, well, wait a second. I did something wrong. I don't want to get no severance, so I'm going to accept that offer. Except that is not what you're owed, and here's why. It is extremely difficult to let someone go without severance. We call that a termination for cause. Very difficult to terminate for cause. It's not enough that you've done something wrong or even a few things wrong. It's the capital punishment of the employment relationship. It's reserved for the worst offenders. So it's so often the case where an employer alleges cause or says that it has cause when in fact it doesn't. And cause is an all or nothing type of a situation. If there's no cause 100%, there's no cause at all. So that employee that may have done something wrong could still be owed, and likely is owed, their full severance. So even if you've done something wrong, if you are let go, don't accept that offer. Let's talk, because chances are, even with you doing something wrong, you're owed a lot more than what you've been offered.
Okay, fact number two, the employer uses a severance offer deadline as a pressure tactic.
That's the big one, Dana. That is the reason why most people accept completely inadequate offers, because there's that deadline. You know, Friday at 5, you have to sign this by then, and if you don't, that offer goes away. Well, that's ridiculous. Your legal rights don't expire Friday at 5. In fact, your legal rights don't expire for 2 years. That deadline is a pressure tactic. What an employer often hopes is that you'll be afraid to lose something and you'll sign it, not even getting legal advice, not understanding what you're owed. Don't let that happen to you. chances are over 90% of chance, frankly, that if you've been offered the severance package, that offer is inadequate. Most people will accept it because they don't know any better and they're afraid of that deadline. If you're watching the show, you know better now. You won't let that happen to you. Don't be afraid of that deadline.
That's very common. Okay, fact number 3, the employee believes and the employer hopes that they can't afford to take action.
Well, a lot of times when people tell me, that they accepted offers that are not good and I ask why, they say, well, I was afraid of the process of getting better severance. Is it going to be long, complicated, expensive? Unfortunately for them, that's a mistake, because when it comes to employment law, certainly when it comes to severance, it's not a long process. It's not a complicated process or an expensive one. Usually, it's a process that resolves within a couple of weeks. And in most cases, the company ends up paying for the legal fees. You can work on a contingency basis. So don't be afraid of the process. Don't give the employer the benefit of your severance money just because you're afraid of pursuing it. I know that happens often, but I'm here to tell you that should not be a concern.
Okay, fact number 4, the employee tries to navigate severance package negotiations themselves.
That's right. Yeah. Not a good idea. No. When it comes to that offer, the severance offer, you may not know what to ask for, how much you're owed. You may try to negotiate, you get something in return, and you'll accept it not knowing you're owed a lot more. So one of the main reasons why people end up accepting severance offers that are not adequate is because they didn't negotiate properly, or they try to negotiate on their own and they didn't do it the best way possible. They still didn't get a good offer. Don't let that happen, okay? You're at a disadvantage if you try to do it on your own. Let us do what we do, which is to get you the severance that you're owed.
Okay, fact number 5, the employer doesn't realize the employee is entitled to more severance, maybe because they rely only on the Ministry of Labor.
Absolutely. So here's the problem. If you were to call the Ministry of Labor right now in Ontario and ask them how much severance you're owed, unfortunately, you're going to get the wrong answer, because the Ministry of Labor can only advise you with respect to your minimum entitlements, not your full entitlements. And a lot of people call the Ministry of Labor, find out the wrong information, and relying on that information, accept inadequate severance. When it comes to severance, you cannot call the Ministry of Labor. You can call them for an overtime issue, for a vacation pay issue, no problem. When it comes to employment law, or certainly when it comes to severance, you have to speak with an employment lawyer. Otherwise, you're going to risk accepting a lot less than what you're owed.
Okay, let's listen to another phone call from one of your live radio shows. Take a listen.
I work for a public company here, and I'm partly sales involved, and they've hired a new gentleman who's going to be taking over. The old boss was soon to retire, and he's been really grinding me around. I don't want to really quit because I know there won't be a severance package, and I also don't want to get fired for going back at him and responding to him in a negative way. I was wondering, what options do I have?
What advice do you have for that employee?
So, Dana, we all have a right to work in a healthy work environment. That's a basic right that every employee in this country has. And if your employer doesn't provide that work environment, if you work in a poison work environment, that's illegal and it can result in a constructive dismissal. The key here is being able to establish that harassment, the mistreatment. Keep in mind, the person that's harassing him is not going to put up their hand in shame and say, yes, I did it. So it's going to be up to the employee to establish that harassment. So how do you do that? Is there a recording? Is there a witness? Do you have notes, an email, something in writing, something that you can corroborate the harassment? If you can establish that you've been harassed, mistreated, then you can treat that potentially as a constructive dismissal. That allows you to leave and still get your severance, even if you're the one quitting. So don't just quit without having that. Always happy to chat to people, to talk to them how we build up that case, how we prove that harassment. But it is a very common thing to have constructive dismissal as a result of harassment, and the law knows exactly how to deal with those situations.
Such important advice. Thanks, Lior. Okay, let's take a short break, and when we come back, Lior from employmentlawyer.ca will discuss termination rights for someone accused of destroying company property and a disability leave dilemma. That's next on Ask a Lawyer. Stick around.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask a Lawyer. Lior Simfuru from employmentlawyer.ca is taking questions about your workplace rights. If you want to get in touch with Lior and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. We still have lots more to discuss. Here's another call from your radio show.
I was terminated from my job on October 30th of last year, and without warning. I was accused of destroying property, which I had no knowledge of. So I'm wondering what kind of recourse I might have. I worked there 6.5 years, logistics manager.
Obviously, then, destroying company property would be a very bad thing if he in fact did it. Well, he says he didn't do it. If that is true, if he didn't do what he is accused of doing, well, this can only be one thing. It could be a without cause termination, meaning he is owed severance. There may not be a mechanism there to get him his job back, even though he may not have done anything wrong. But what the law can do is compensate him by way of severance. That wouldn't be available to him if he was guilty of significant misconduct. But if the company got this wrong, if he didn't do what he's accused of, he's absolutely owed his severance. So the question then becomes, well, how much severance? Well, here's what we're going to do. We're going to go back to our severance calculator, which you can find at pocketemploymentlawyer.ca. Let's plug in his information and let's see how much severance he is owed. Same thing as you can do at home yourself with your situation. So we know he's a logistics manager, 64 years old, been with his employer for 6.5 years. His employer may say, no, you're not owed any severance. Well, if in fact he didn't do what he's accused of doing, he's owed severance, and you can see on the screen he's owed 8 to 10 months of pay. That's a lot of severance. And obviously the difference between being let go for cause and not getting any severance and getting 10 months of pay is significant. We call that a wrongful dismissal. So that's how easy it is to find out how much severance you're owed. Just go to pocketemploymentlawyer.ca, use the severance calculator. It's there for you.
Okay, let's jump to another question. This one from one of your live streams on Facebook and YouTube, which you can find by going to @stlawyers.ca. I've been on long-term disability for nearly 2 years. The company I work for has just transferred to new owners who have decided not to keep any employees currently on a leave of absence. On top of that, my insurance provider says they plan on cutting off my payments. I'm in dire need of help.
Well, I mean, I shake my head when I hear stories like that. Let's be very clear. It's not up to the employer to decide out of the kindness of their heart if they're going to keep someone off on a medical leave of absence. By law, by right, you can be on a medical leave of absence as long as needed. And there's no time limit on it. It doesn't expire after 6 months. And an employer that decides to say, well, that's it, we're letting someone go because they're on a leave of absence, that employer is breaching our human rights code. That's illegal. Not to mention, of course, it's a wrongful dismissal. So it's wrong, it's illegal, and the employee should never accept that. You let the employee stay off as long as they need to be. You follow what the doctor says. If you need to accommodate them afterwards, you have to accommodate. You can't let them go. Now, the other issue, of course, if the insurance company is saying, well, we don't think you're disabled enough, well, that again is illegal. They should also follow what your doctor says. At our office, we have a whole team dealing exclusively with these disability issues and disability insurers. So happy to help anyone where their insurance provider is not paying as they should.
Okay, let's take one last break. When we return, Lior from employmentlawyer.ca will tell us if your employer can refuse to pay a bonus and are rights different between salaried and hourly workers. Stay with us.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask a Lawyer. Lior Simfuru from employmentlawyer.ca is answering your employment law questions. Let's take a look at another situation that your firm encountered recently. Just days after I submitted a request to the company for my performance-based bonus, I was fired. No reason was provided, and they refused to give me the bonus pay I was rightfully earned. What are my options?
Dana, if a bonus is earned, a bonus has to be paid. And what an employer cannot do is pick a convenient termination date to avoid paying that bonus. So that employer try to do something, they'll fail. They'll have to pay the bonus, but it gets even worse for that employer. For playing that game, for trying to avoid paying someone money that they're owed, there could be other damages that they now have to pay. So it's not worth it for the employer to do that. Best advice for employers, if you owe someone any money, pay that money. Trying to avoid it is only going to cost you more money.
Okay, time for one last scenario your team has come across recently. Does your right to a severance package change if you're a manager, salaried employee, or paid by the hour? Great question.
Great question. There's a lot of misconception there saying, well, if I'm a part-time or salary or hourly, that somehow avoids my severance or changes my severance entitlements. Let's be very clear. You get severance in all of those scenarios. If you had a job and you lost that job, you are owed severance. It's as simple as that. Now, the type of job may impact the amount of severance. The more senior a position you have, the greater the entitlements, et cetera. But bottom line is severance has to be paid. And if you're someone, by the way, where your compensation changes, maybe there's commissions and you make a different amount every month, we'll simply look at an average and use that average compensation to calculate your severance. An employer cannot avoid paying you in that situation.
Leroy, thank you so much. Always such amazing information. You can catch legal experts from employmentlawyer.ca on Ask a Lawyer every Wednesday on CP24. For more information on this show at employmentlawyer.ca, visit cp24.com/askalawyer. If you would like to have your employment law questions answered live on the air, tune in to the Employment Law Show, hosted by Lior every Sunday from 1 to 2 p.m. on News Talk 1010. Join us next week as we review various workplace issues that could cost employers big time. Thanks for watching. See you next time.